Welcome to the deep dive. Today, we're going to be looking at something a little different, South African contract law.
Oh, very interesting.
Yeah, you sent over some fascinating materials for this one,
I did.
including like excerpts from a textbook
Yeah.
and what looks like a study guide.
Yes, a study guide.
So we're going to be going through those today.
Absolutely.
Now, I know contract law might sound a little bit dry,
Okay.
but trust me, it's way more fascinating than you might think.
It really is. And it touches so many parts of our lives. You know, we make contracts every day,
Right.
whether we realize it or not.
Yeah, absolutely. So where do we even begin with something as big as South African contract law?
Well, the study guide actually gives us a really nice kind of roadmap through it.
Okay.
It breaks the subject down into 6 learning units.
Okay.
And it starts right at the fundamentals,
Yeah.
What is a contract? Where does it come from? How does it fit into the broader South African legal system?
Okay, so Unit 1 is all about, like, laying the groundwork.
Exactly.
Okay.
Really getting those foundations in place.
All right, so what are some of the key takeaways, then, from Unit 1?
Well, it starts by defining a contract, right? So at its heart,
Mm-hmm.
a contract is a legally binding agreement between 2 or more people with the intention of creating legal obligations, so it's not just a casual promise.
Right.
It has to have that legal weight behind it.
Yeah, so like a pinky promise doesn't count.
A pinky promise, generally no, unless you're in a very specific legal context.
Okay.
But then it takes us deeper. It explores how this idea of a contract evolved over time.
Okay.
And we see, these traces of Roman law, Roman Dutch law mixed with English influences
Wow.
to create this kind of unique system that we have in South Africa today.
It's like a legal melting pot.
Exactly.
How does that history play out in today's world? Like, how does it affect you and me, just normal, everyday people?
That's a great question. And one of the really important takeaways from Unit 1 is that South Africa's contract law isn't just about, cold, hard rules.
Right.
It's been shaped by the Constitution,
Okay.
which introduces values like good faith, fairness, and even Ubuntu into the mix.
So it's not just about what's written down, it's also about the spirit of the agreement.
Exactly. It's about ensuring that contracts aren't used to exploit or take advantage of people.
Right.
It's about fostering ethical and just relationships.
Okay, so the Consumer Protection Act comes in here, right, to sort of level the playing field.
Absolutely. The CPA is all about protecting consumers, making sure that they're not being tricked or misled into unfair agreements.
Right.
It gives them certain rights and remedies if a contract turns out to be unfair or if a business doesn't hold up their end of the bargain.
Okay, so we've got this foundation.
Yep.
We know what a contract is.
Right.
We know the values that it's built upon.
Yep.
What's next?
So Unit 2 dives into the nitty-gritty
Here we go.
of actually forming a contract. How do we get from that initial idea to a legally binding agreement?
Yeah.
And it breaks it down into 6 essential elements.
6.
Yeah. 6 things you need to have in place for a valid contract.
Wow. Okay, I'm already feeling overwhelmed.
Don't worry, we'll break it down.
Okay.
So these elements are consensus capacity formalities, legality, possibility, and certainty.
Oh my goodness, that's a lot to remember.
It is, but they're all really important. Each one plays a crucial role in making sure the contract is solid and enforceable.
Okay, let's start with consensus because I think that's one that trips people up a lot.
It definitely is. Consensus is all about making sure that the parties are on the same page,
Right.
that there's a genuine meeting of the minds.
Like they both understand and agree to the same thing.
Exactly. And the study guide actually highlights this with a really helpful diagram.
Oh, okay.
It shows how intentions can sometimes get misaligned. What one person thinks they're agreeing to might not be what the other person has in mind.
That's where things could get messy, right?
Absolutely. Miscommunication is a recipe for contract disputes.
So what if I think I'm agreeing to one thing, but the other person interprets it differently?
Well, that's why we have these legal principles to help us figure out what the true intention was.
Okay.
And the textbook goes into this in more detail, exploring how South African law balances subjective and objective approaches to contract formation.
Subjective and objective, I'm not sure I follow.
So subjective is all about what was actually going on in the person's mind. What did they truly believe they were agreeing to?
Right.
Whereas objective is about looking at the external factors.
Okay.
What a reasonable person would have understood from the words and actions of the parties.
Right. So it's not just about what I secretly thought in my head. It's also about how I expressed that intention.
Exactly.
Okay.
And the law takes both of those into account when determining whether there was genuine consensus.
That makes sense.
And there's this really interesting concept called justice error, which essentially means a reasonable mistake.
So if I make a mistake, but it's understandable, given the circumstances, I might have a way out of the contract.
That's the idea. The law recognizes that we're all human and we all make mistakes.
Right.
But the mistake has to be reasonable. You can't just claim ignorance as an excuse to get out of a bad deal.
So how do we know if a mistake is reasonable or not?
Well, the textbook uses this fascinating case, George v. Fairmead, to illustrate this.
Okay, tell me more.
So in this case, a man signed a hotel registration form that included a clause limiting the hotel's liability for lost goods.
Okay.
But he later claimed he hadn't read it and shouldn't be bound by it.
Oh, so just because you sign something doesn't mean you're automatically stuck with every single term?
That's the question the court had to grapple with,
Okay.
Was his mistake reasonable?
Right.
And they ultimately ruled that a reasonable person would have expected such a clause in a hotel registration form, so he was bound by it.
Okay, so it highlights the importance of reading those terms and conditions, no matter how tedious they might seem.
Absolutely. It's always best to be informed and to know what you're getting yourself into.
Right before you sign on the dotted line.
Exactly.
Okay, so we've talked about consensus, which is one of the 6 elements.
It is.
What about the others?
So capacity focuses on who can legally enter into a contract. Are they old enough? Are they mentally capable
Right.
of understanding the agreement?
Like if someone is very young or maybe has a mental disability that affects their judgment.
Exactly. And the study guide delves into situations where someone might lack the capacity to contract, like minors, for example.
Okay, so a 10-year-old can't just go and sign a contract to buy a car.
Not without their parent or guardian's consent.
Right.
And even then, there are certain types of contracts that minors can't enter into at all.
Okay,
Like contracts that involve taking on debt.
that makes sense. You wouldn't want to burden a child with financial obligations they can't handle.
Exactly. The law is there to protect those who might be more vulnerable.
Okay, and what about formalities? Does that mean that all contracts have to be written down to be valid?
Not all of them, but certain types of contracts do have to be in writing.
Okay,
For example, contract involving the sale of land.
right. You wouldn't want to buy a house based on just a handshake agreement.
Exactly. You need that written proof to avoid disputes down the line.
Okay, what about legality? Does that mean that a contract can't involve anything illegal?
Precisely. A contract to do something illegal is simply unenforceable.
Right.
The courts won't uphold an agreement that goes against the law.
Okay, that makes sense. And then there's possibility.
Possibility ensures that the contract can actually be carried out.
So you can't have a contract to deliver something that doesn't exist.
Exactly, or a contract to do something that's physically impossible.
Okay. And finally, there's certainty.
Yes, certainty is all about making sure the terms of the contract are clear and definite.
So it's like writing a recipe. You need precise measurements and instructions for it to work properly.
I love that analogy. Vague terms would be a recipe for disaster.
Exactly.
If the terms are unclear, it's going to be very difficult to enforce the agreement.
Right, because nobody knows what they actually agreed to.
Exactly, and the study guide really emphasizes that these 6 elements are like the building blocks of a valid contract.
Right.
If any one of them is missing, the whole structure might collapse.
Okay, this is starting to make sense now. So we got the foundation of what a contract is and those key elements needed to form one. But how do we move beyond these basics?
Well, Unit 3 in the study guide takes us deeper. It delves into the contents of a contract.
Okay.
What are the different types of terms that make up these agreements?
Okay.
And how are those terms interpreted by the courts?
So we're moving from the what of a contract to the how.
Exactly.
Okay.
How do these agreements actually work in practice?
All right, sounds like we're about to uncover the hidden layers of contracts.
We certainly are, and those hidden layers are crucial for understanding how contracts really work in the real world.
Exciting.
Very exciting.
Welcome back to the Deep Dive. We're picking up right where we left off, delving deeper into South African contract law with your study guide and those textbook excerpts you sent.
Yeah, some fascinating stuff in there.
Yeah, last time we established like what a contract actually is.
Right.
And those key elements that are needed to actually form one.
Yeah, those building blocks, from consensus and capacity to those often overlooked formalities and legality.
Right. But now I'm really curious about what's inside those contracts. What kind of terms and conditions do they contain? How do they actually work in practice?
Well, that's where Unit 3 of your study guide comes in. It focuses on the contents of a contract.
Okay. The contents.
Yeah, it sort of breaks it down into 2 main categories. We've
Okay.
got express terms and we've got implied terms.
Express terms, those sound pretty straightforward. Like, those are the things that the parties explicitly agree to, right?
Absolutely. Express terms are the terms that are specifically stated in the contract, whether they're written down or spoken.
Okay.
Think of it like the price of a product or the delivery date for a service.
Right.
These are things that are clearly laid out for both parties to see.
Okay, that makes sense. But what about implied terms? Those sound a bit more mysterious.
Right.
Like those secret ingredients hidden in the fine print.
I love that analogy. Implied term, if they aren't explicitly stated, they're not written down in black and white, but they're still considered part of the agreement.
Okay, so even if something isn't explicitly written down, it can still be binding.
It can, and this is where things can get a little bit tricky.
Right, that seems like a recipe for misunderstandings.
It can be, and this is why understanding implied terms is so crucial.
Okay.
Take, for example, the duty of good faith.
Okay.
This is a really fundamental principle in South African law that all contracts are based on this idea of good faith,
Okay.
meaning that the parties are expected to act honestly and fairly towards each other.
So even if a contract doesn't specifically say be nice and play fair,
Right.
that expectation is like woven into the agreement.
Absolutely. It's kind of like an invisible thread running through every single contract.
Okay, so it's not just about what's written down, it's also about the spirit of the agreement.
Exactly. And the textbook actually highlights another common implied term,
Oh, okay.
which is the seller's warranty against latent defects.
Okay, latent defects, so like hidden problems.
Right, exactly. So this means that when you buy something, the law implies a guarantee that it's free from these hidden defects that would make it unfit for its intended purpose.
Okay,
So, if you buy a car and it turns out the engine is completely shot
right.
and the seller knew about it but didn't disclose it,
Yeah.
you have legal recourse.
Okay, that's reassuring.
Yeah, the law protects buyers from those kind of unfair situations.
Okay, but going back to those express terms,
Right.
there's a crucial rule to keep in mind here.
There is
Caveat subscriptor.
caveat subscriptor.
Now that sounds ominous. What does that even mean?
It's Latin. It essentially means let the signer beware.
Oh, okay.
And it boils down to this. If you sign a contract, you are bound by its terms,
Even if I didn't read them.
even if you didn't read them.
Ouch, that's a harsh lesson to learn.
It can be the law kind of assumes that your signature indicates agreement,
Okay.
even if you later claim ignorance.
So no take-backsies.
Not usually, although there are some exceptions. Like if the other party misrepresented the contents of the contract,
Yeah.
or if there was some kind of fraud involved.
Right, like if they tricked me into signing.
Exactly.
Okay, but what about those super lengthy standard form contracts? The ones that are like full of legal jargon that nobody actually reads?
You're bringing up a really important point.
Yeah.
The law does recognize the fairness challenges that those kind of contracts pose.
Okay.
Think about those online terms and conditions
Right.
that we all just scroll through without really reading.
Yep.
The Consumer Protection Act steps in here as well.
Okay, how so?
It requires businesses to highlight certain important terms in a way that's clear and conspicuous.
Okay, so it's like a safety net to prevent consumers from being blindsided by these obscure clauses that they never even knew existed.
Exactly.
Exactly.
It's about making sure that consumers are at least aware of those key terms that really affect their rights and obligations.
This is eye-opening, this deep dive into the contents of contracts. We've uncovered these explicit promises and these hidden expectations.
Right.
And it's clear that they both play like a vital role.
They do.
But what happens when those promises are broken?
That's a great transition because Unit 4 tackles the thorny issue of breach of contract.
Breach of contract when those agreements go sour.
Yeah, when things go wrong.
So what exactly constitutes a breach?
Well, breach of contract is essentially when a party fails to perform their obligations as agreed.
Okay.
They don't do what they promised to do.
Right.
And the study guide actually outlines various forms of breach.
Okay.
So we've got things like mora debitoris, which is where the debtor is late in fulfilling their obligation.
Right.
And then we've got mora creditoris,
Okay.
where the creditor is late in accepting performance.
So it's not just about failing to deliver altogether, it can also be about the timing.
Absolutely.
Okay.
Fulfilling those obligations properly.
Right.
And then there's positive malperformance.
Positive malperformance.
Where the party does perform. They do try to fulfill their obligation.
Yeah.
But they do it in a defective or incomplete manner.
Okay.
They think of a builder who uses substandard materials.
Right.
Or a caterer who delivers the wrong food for your event.
Oh, that would be a disaster.
It would be a breach of contract.
Okay, so it sounds like there are nuances to these breaches, different ways that things can go wrong.
Absolutely. And each type of breach comes with its own set of legal consequences.
Okay.
But the study guide emphasizes that one of the primary remedies for breach of contract is damages.
Damages, so that's basically like compensation for the harm caused by the breach.
Exactly.
Okay.
Damages aim to put the innocent party back in the position they would have been in
Right.
if the contract had been properly performed.
So if I had ordered a chocolate cake and you delivered a vanilla cake,
Right.
you would have to pay me damages to compensate for my disappointment.
It might not be that simple, but you get the idea.
Yep.
Damages might include things like lost profits, wasted expenses,
Okay.
or any other financial harm directly caused by the breach.
Right, so it's not just about emotional distress.
It's primarily about financial loss.
Okay.
Making the innocent party whole again.
But how are those damages actually calculated?
Well, it can get quite intricate.
Right, I imagine so.
The textbook goes into this in more detail, explaining concepts like general damages,
General damage,
which cover foreseeable losses, and then there's
special damages.
which require specific proof.
So you have to actually like show the receipts and the evidence.
Exactly. And then there's this interesting rule called the mitigation rule,
Litigation.
which basically obligates the innocent party to minimize their losses.
So you can't just sit back and watch the damages pile up.
Right.
You have to take reasonable steps to limit the harm.
Exactly. You can't just make the situation worse and then expect the other party to fit the bill.
Okay, that makes sense. And the textbook also highlights penalty clauses,
Yes.
which I've heard of before.
So these are predetermined amounts
Right.
that the parties agree upon upfront
Okay.
to be payable in case of a specific breach.
So it's like a pre-negotiated consequence.
Exactly.
Okay.
It avoids the need for lengthy court battles to figure out the exact amount of damages.
Saves everyone time and money.
Exactly. But the study guide does caution that these clauses can't be excessively harsh or disproportionate,
Okay.
to the actual harm suffered.
Right, so you can't just like slap on a R1,000,000 penalty for being 5 minutes late.
Exactly. It has to be reasonable and fair.
Okay, it seems like South African law has this well-balanced approach to dealing with breach of contract.
It does. The system aims to be both fair and efficient.
Okay.
Recognizing the importance of upholding agreements, but also protecting parties from unreasonable consequences.
This exploration of breach of contract has been fascinating.
It is a complex area.
And it highlights the importance of those remedies, for ensuring that contracts are taken seriously.
Absolutely.
But what about situations where a contract involves more than just two parties? Can contracts create right and obligations for third parties who aren't directly involved in the agreement?
That's an excellent question. And it leads us to this concept of privity of contract.
Privity of contract.
Which is the focus of Unit 5.
Okay, privity of contract, it sounds a bit like an exclusive club.
It kind of is. The general rule is that contracts create rights and obligations only for the parties who are involved in the agreement.
Okay.
So a third party can't just come along and enforce the terms even if they benefit from it.
Right.
Nor can they be held liable if the contract is breached.
Okay, so if you and I have a contract and it benefits my friend,
Right.
my friend can't sue you if you break the contract.
That's right.
Okay.
They're not a party to our agreement, so they have no legal standing.
Okay, but are there any exceptions to this rule?
There are some important exceptions.
Okay, I was hoping so.
The study guide points out a couple of key ones. One is representation,
Representation.
where someone acts on behalf of another person.
Okay.
So, for example, if I hire a real estate agent to sell my house,
Right.
they can enter into a contract with a buyer on my behalf.
Okay, so the agent is like my stand-in.
Exactly. They're acting as my representative, binding me the principal
Okay.
to the sale agreement.
That makes sense. And the textbook actually goes into more detail about this, explaining the different types of agents.
It does.
Okay.
And, the scope of their authority.
Okay, so there are rules about what an agent can and can't do.
Absolutely.
All right, and what about those situations where a contract is specifically intended to benefit a third party even though they weren't involved in forming it?
Right.
We touched on this earlier with the stipulatio alteria.
Yes, the stipulatio alteria is a key exception to that privity rule.
Okay.
And the textbook provides a really classic example.
Okay, let's hear it.
A life insurance policy.
Okay.
Where the policyholder names a beneficiary.
Right.
So the beneficiary, although they're not a party to the contract between the policyholder and the insurance company,
Yeah.
they have the right to receive the payout upon the policyholder's death.
Right, so they benefit from the contract even though they didn't sign it.
Exactly.
It would be pretty unfair if they have no way to enforce their rights.
It would.
Okay, then we've got representation and stipulatio alteri.
Yes.
Two important exceptions to the privity of contract rule.
They highlight the flexibility of contract law.
Right.
Accommodating those situations where third-party interests need to be recognized and protected.
This is this journey through these the intricacies of contracts is proving to be way more interesting than I initially thought.
It's a fascinating area of law.
We've gone from understanding those foundational elements to we delved into those express and implied terms.
Yes.
We tackled breach of contract and remedies.
You did?
And we even explored those exceptions to the privity rule.
It's amazing how much ground we've covered.
It is, but I can't help but wonder, how do these contractual journeys eventually come to an end? Is that always a smooth landing, or can things get a little turbulent?
Well, that's an excellent question, and it leads us perfectly into the final unit of your study guide.
Here we go.
Unit 6 focuses on the termination of contracts.
Okay.
Exploring the different ways that these legal agreements can come to a close.
It sounds like we're about to witness the final act of this contract drama.
We are.
All right, I'm ready to see how these stories reach their resolution. Welcome back to the Deep Dive. We're in the final stretch now of our exploration of South African contract law. using your study materials as our guide.
Yes, it's been quite a journey.
Yeah, we've already uncovered those like foundational elements. We've explored those, the contents of contract. We've even tackled breach of contract remedies and even looked at those exceptions to the privity rule.
And now we're going to see how these contractual journeys come to an end.
Exactly. So how do contracts actually end? Is it always a smooth landing or can things get a bit turbulent?
That's where Unit 6 of your study guide comes in.
Okay, Unit 6,
It focuses on the termination of contracts.
the termination.
Yeah, it outlines the various ways that these legal agreements can reach their conclusion.
Okay.
Some are quite straightforward, some are a little bit more complex.
All right, so let's break it down. What's the most common way for a contract to end?
Well, the most straightforward scenario is performance,
Okay.
Once both parties have fulfilled their obligations as agreed, the contract naturally comes to an end.
So it's like a successful business transaction goods, delivered payment, made everyone's happy.
Exactly. It's like a perfectly choreographed dance. Each partner executes their steps flawlessly, and then the performance concludes with a satisfying final bow.
I love that analogy, but as we've already seen, not all contracts end so harmoniously.
Right.
We've talked about breach of contract where one party fails to uphold their end of the bargain. And in some cases, that breach can lead to cancellation, which basically terminates the contract, like a sudden interruption in the dance. One partner stumbles and the performance comes to an abrupt halt.
That's a great way to put it.
But are there other ways for contracts to end, even if there hasn't been a breach?
There are.
Okay.
Parties can always agree to end a contract,
Okay.
even if all the obligations haven't been fully performed.
Right.
This is known as mutual rescission.
Mutual rescission.
Yeah, it's basically a negotiated settlement,
Okay.
where both sides decide to walk away, even if it means leaving some things unfinished.
So it's like an amicable divorce.
It can be.
Okay.
It's a way for parties to part ways, without the need for a dramatic legal showdown.
Right. I imagine this is particularly useful when circumstances change and the original agreement just doesn't make sense anymore.
Absolutely. Life happens, things change, and contracts need to be flexible enough to adapt.
Okay. And then there's supervening impossibility of performance.
Yes, this is a big one.
Yeah, we touched on this earlier with those examples like a natural disaster destroying crops, a farmer promised to sell,
Right.
or a musician's illness preventing a concert performance.
Exactly. So in these cases, it becomes objectively impossible
Right.
for one or both parties to fulfill their obligations.
Right, it's like a force majeure clause.
It is very similar. It
Okay.
acknowledges that some events are just beyond our control,
Right.
and it would be unfair to hold parties liable in those situations.
But the study guide emphasizes that this impossibility has to be objective.
Yes.
It can't just be a matter of inconvenience or increased costs.
Right. You can't just use it as an excuse to get out of a bad deal.
It has to be like legitimately impossible.
Exactly.
Okay, so we've got performance breach agreement and impossibility.
Yes.
4 major pathways to contract terminations. Are there any others?
There are a couple more that the study guide highlights. One is prescription,
Prescription.
which deals with the extinction of debts over time.
Okay.
So South Africa has a prescription act,
Okay.
which sets specific time limits for taking legal action to enforce a debt.
Okay, so if I owe you money,
Right.
you have a limited time to take me to court to get it back.
Exactly. If you wait too long, the debt prescribes, meaning you can no longer enforce it.
So it's like a statute of limitations.
It is. It's designed to promote legal certainty and to avoid those situations where evidence might be lost or memories become busy.
Right. It brings a sense of finality to
Exactly.
those long-forgotten debts.
And then finally, we have novation,
Novation.
which is a fancy way of saying replacing an existing obligation with a new one.
Okay.
So this can happen through an agreement between the parties,
Okay.
or in some cases by operation of law.
So it's like a contract makeover, swapping out old terms for new ones that better reflect the current situation.
Exactly. Novation can be a really valuable tool
Okay.
for adapting to changing circumstances and making sure that contracts remain relevant and workable.
Wow, we've covered so much ground in this deep dive into South African contract law. We went from understanding those fundamental elements
We did.
to exploring the intricacies of their contents. We navigated the complexities of breach and remedies.
Yes.
And now we understand how those contractual journeys eventually comes to an end.
It's been quite a journey.
It's been an incredibly insightful exploration. It's clear that contract law isn't just a dry set of rules.
Right.
It's a living framework that underpins so many of our interactions and transactions.
It really is.
Inferring fairness, promoting ethical behavior, and ultimately shaping the very fabric of our commercial relationships.
It's about creating a system where people can make agreements with confidence, knowing that their rights and obligations are protected.
Absolutely. And as we navigate the world of contracts, remember those key takeaways: the importance of clarity and consensus, the role of good faith, and those various mechanisms for addressing those inevitable bumps in the road.
And if those bumps get too big, don't be afraid to seek legal advice.
Yes, good advice, always a good idea.
A solid understanding of contract law empowers you to engage in agreements with confidence, knowing the rules of the game and how to play it fairly and effectively.
Thank you for joining us on this deep dive into the fascinating world of South African contract law. Until next time, happy contracting.